In this video, I want us to discuss the right to access to justice under Article 48 of the Constitution of Kenya 2010 and its achievability. Now, the right to access to justice is a cornerstone of constitutional democracy. It ensures that individuals can approach courts and other dispute resolution mechanisms to seek enforcement of rights and remedies. In Kenya, Article 48 of the Constitution of Kenya 2010 provides that the state shall ensure access to justice for all persons, and this right is reinforced by Article 159 of the Constitution on judicial authority and principles of justice, and Article 50 on right to fair hearing. Now, together, these provisions aim to remove barriers that prevent individuals from obtaining justice. However, the practical question is whether this right is fully achievable within Kenya's existing legal and institutional framework. So, what is the meaning of the right to access to justice as per Article 48 of the Constitution? You see, access to justice means more than the ability to go to court. It includes, physical access to courts. It includes financial affordability. It includes legal representation. It includes timely resolution of disputes. It includes procedural fairness, and it also includes, availability of alternative dispute resolution mechanisms. It ensures that legal rights are meaningful in practice, not just on paper. Now, the constitutional basis of Article 48 guarantees, access to justice for all persons. Article 159(2) requires that justice shall be done to all without delay, not obstructed by technicalities, and also promoted through alternative dispute resolution. Article 50 guarantees fair hearing. So, what are the components of access to justice? The first component of access to justice is physical accessibility. In that, courts must be geographically accessible. In fact, devolution has improved, access through magistrate courts in counties. The second component of access to justice is financial accessibility. You see, justice must not depend on wealth, so that legal fees, court fees, and lawyer costs can be barriers to access to justice. The third component of access to justice is legal aid. Now, legal aid ensures representation for the poor. The Legal Aid Act of 2016 actually operationalized this particular right. The fourth component of access to justice is procedural fairness. Courts must avoid, technical barriers. Article 159(2)(d) requires justice without undue regard to technicalities. The fifth component of access to justice is timely justice. So that delay, undermines justice. Justice delayed, as they say, is justice denied. Let's look at the judicial interpretation of access to justice. You see, in the case of Mitu Bell Welfare Society versus Kenya Airports Authority, the facts of this particular case were that residents were forcibly evicted from informal settlements. And the issue was whether their constitutional rights, including access to justice and housing, were violated. And the rule is that Article 48 guarantees access to justice and that courts must enforce socio-economic rights. The application of this particular case is that the Supreme Court emphasized that courts must be accessible, they must be affordable, and they must be effective in protecting rights. So the conclusion of this particular case is that the evictions without due process violated constitutional rights. The significance of this case is that it reinforced, substantive access to justice. It expanded, protection for vulnerable groups, and it emphasized, practical rather than theoretical justice. If you look at the case of Dry Associates Limited versus Capital Markets Authority, the facts of this particular case, was that there was a challenge to regulatory sanctions without adequate hearing. And the issue was whether fair hearing and access to justice were violated. And the rule is that Article 50 guarantees fair administrative and judicial processes. The application of this particular case was that the court emphasized due process rights. And the conclusion was that procedural fairness is part of access to justice. If you look at the case of Republic versus Karisa Chengo, Courts emphasized, proper jurisdiction and fair criminal processes, reinforcing, structured, access to justice. Now, I want us to look at the mechanisms, promoting access to justice in Kenya. Now, the first mechanism promoting, access to justice in Kenya is judicial reforms. And here we have, the digitization of court systems, e-filing, the establishment of specialized courts like the Environment and Land Court, and also the Employment Court, and also case management systems. You see, these have improved, efficiency in the justice system in Kenya. The second mechanism promoting access to justice in Kenya is alternative dispute resolution, called ADR. Article 159(2) of the Constitution, promotes, mediation, arbitration, and traditional dispute resolution. In fact, ADR reduces costs, and it also reduces delays. The third mechanism promoting access to justice in Kenya is legal aid system. You see, the legal aid provides, legal representation for indigent people and persons. It also provides, legal awareness programs, and it also provides, paralegal support. The fourth mechanism promoting access to justice in Kenya is small claims court. These are created, to resolve minor civil disputes quickly and also cheaply. And these, have improved access for ordinary citizens to justice. So what are the challenges to access to justice in Kenya? You see, despite constitutional guarantees, several barriers remain. The first challenge to access to justice in Kenya is poverty and economic barriers. You see, legal services in Kenya remain extremely expensive, so that many citizens cannot afford lawyers, they cannot afford, filing fees, they cannot afford, transport to courts. And you see, this limits, practical access. The second challenge to access to justice in Kenya is delays in the judicial processes, so that court backlog, remain a major issue in Kenya. Cases may actually take years and sometimes even decades to conclude. And you see, this undermines, Article 48 of the Constitution. The third challenge to access to justice in Kenya is geographical barriers, and rural areas, still face limited access to courts. Although, we have improved, access, to justice, especially in counties, but disparities still remain in Kenya. The fourth challenge to access to justice in Kenya is lack of awareness. Many citizens are unaware of their legal rights. And you see, this unawareness, limits enforcement of justice. The fifth challenge to access to justice in Kenya is corruption and institutional weaknesses. You see, corruption can distort justice delivery, and this undermines trust in the system. Now, let's look at the theoretical perspectives of law. Daisy came up with the idea of the rule of law, and Daisy emphasized, equality before the law, in that access to justice is essential to making equality real. So that without access, rule of law becomes theoretical. Roscoe Pound, views law as social engineering. Pound argued that law should balance, social interest and ensure justice is practically accessible. Access to justice is therefore, a tool of social engineering. So what is the extent to which access to justice is achievable in Kenya? The first extent to which access to justice is achievable in Kenya is, number one, the high level of constitutional commitment. You see, Kenya is one of the strongest constitutional frameworks globally. Article 48 of the Constitution of Kenya explicitly guarantees, access to justice. Article 159 removes, technical barriers, and Article 50 ensures fair hearing. The second extent to which access to justice is achievable in Kenya is institutional progress. That is improved, judiciary infrastructure, digitization of courts, expansion of legal aid, and also ADR, mechanisms. The third extent to which access to justice is achievable in Kenya is persistent practical limitations, so that despite progress, inequality, affect access, delays, persist, legal awareness is low, and also enforcement gaps, exist. If you look at the case of Federation of Women Lawyers, FIDA Kenya versus Attorney General, the courts emphasized gender equality in justice systems, but also highlighted implementation gaps. Now, here's a critical evaluation of the statement. You see, the strength are that we have, strong, constitutional protection. We have judicial enforcement of rights. We have expanded legal aid. We have ADR systems, and we also have institutional reforms. And the weaknesses are that we have poverty, which limits access. We have delays in courts. We have corruption. We have uneven geographical access, and we also have limited awareness. The conclusion is that the right to access to justice under Article 48 of the Constitution of Kenya 2010 is a fundamental constitutional guarantee designed to ensure that all persons can seek and obtain justice without barriers. Kenya has made significant progress through constitutional reforms, through judicial interpretation, through legal aid systems, and also through institutional innovations such as ADR and specialized courts. However, full realization of this right remains constrained by economic inequality, by delays in the judicial systems, by limited awareness, and also by institutional challenges. Therefore, while access to justice is legally well established and progressively being realized in Kenya, it is not yet fully achieved in practice. So that continued reforms are necessary to bridge the gap between constitutional promise and lived reality. My name is Bikete. If it is your first time here, make sure to follow this channel and to subscribe for more legal lessons.